And second thing, which I want to mention was that for today's purposes, I will request and defer to Nilang to do most of the heavy lifting because he has hands-on experience of handling the cases relevant to today's discussion. I will provide some supplementary comments and intervene wherever I believe that I may have like to add a comment or otherwise, but I think we are in very good hands with Nilang and allow him to lead this. Over to you, Nilang.
Thank you, sir. Thank you very much. I should just say thank you very much for the opportunity to speak over here, and thank you all of you for dialing in. I think I've already been very generously introduced, so thank you very much for that. I should also mention that I'm a member of the executive committee at Insol India, which is, as you know, a India chapter of Insol International, which is obviously the largest insolvency practitioners body, membership body around the world. Very, very happy to speak here, both in my capacity as a partner at AZB and my capacity as an execcom member of Insol India. I should also introduce my partners who are on this call. What I've done the liberty of doing is, rather than having you hear me speak for hours at end and get completely bored out by that, is to mix it up a little bit and invite some of my partners who have obviously been very, very deeply involved in relation to the FSP processes that we as a firm have run. And in fact, I should mention that we've been very lucky that there have been 3 FSP resolutions in the country, as you know, Dewan Housing, Reliance Capital and Shrey. And the firm here at AZB has handled all 3 of them on behalf of the RBI initially in relation to admitting them into IBC, because that's obviously the first step. And then representing the administrator of each of these companies as their legal counsel. So we've had, ringside seats, so to speak, to this play out. And over the course of today and tomorrow, myself and my partners will go through, what we can disclose in a public forum, what we've seen, how it's different, the issues, and how we've seen, how we've gotten about to resolve them. So I should introduce my partners. I see Suharsh Sinha, who's also dialed in. My partner Amrita Sinha, no relation, and my partner Avinash Subramaniam, who have also dialed in. What we've done is taken the liberty of splitting out each of the 4 cases we're going to speak of, ILNFS, Reliance Capital, Shrey, and Dewan Housing amongst us. So in terms of format, what we'll do is I'll start off by introducing a few of my thoughts around FSPs. We will then move on to ILNFS, which my partner Amrita Sinha will speak of. She's been very active in a couple of ILNFS matters that we've handled. For ILNFS, we were not involved for the company. We've been involved for a lot of investors who have partaken in some of the resolution processes at ILNFS. And my partner Amrita has been very deeply involved in many of those. We will then talk about DHFL, which my partner Avinash is going to lead on. DHFL is something which, again, actually all of us worked on to some extent. Suhash worked on, I worked on, Amrita worked on, Avinash worked on. But Avinash is going to lead the discussion on that. Tomorrow, when we talk about Reliance Capital, I will talk on that case study. And then finally, my partner Suhash will talk about Shrey, the twin Shrey NBFC entities which went into IBC as well. So I'm going to start off with a little bit of background as to how we got to where we are today. There was initially talk of an Indian financial code back in 2013. There was a committee set up called the FLRC, the Financial Laws Reform Committee, which was set up to think through the reform in relation to insolvent financial firms. And fundamentally, I think when we come to talk about insolvency firms, you are already aware that one size does not fit all, even amongst manufacturing companies, service companies, IT companies, etc. But I think the general consensus is that it fits even less so uniformly a financial firm versus a non-financial firm. And if you think about it, that seems relatively obvious because if you take a bank, its entire modus of operation is so significantly different, and its impact on the broader financial community is so significant that there could be a domino effect very quickly and have a national level crisis if it's not managed urgently, carefully, and in a sort of well considered manner. And therefore, world over, not only in India, the insolvency management and potential liquidation of a financial firm has been thought of relatively separately from the manner of looking at manufacturing, service, IT companies, etc. So the FLRC was obviously tasked with the job of thinking through how insolvency resolution, management, and liquidation of financial firms should be carried out. And there was a code, a draft bill, which was thought through after the IFC thinking, called the FRDI bill. And I'll briefly give you a few highlights of how the FRDI bill worked. It's obviously not relevant because that bill has not been passed, and we're not entirely certain when that or a version of that may come through. So this is only for general knowledge, if you will. And the idea of the FRDI bill more broadly is it was sought to be applicable to not only banks, not only NBSCs, but the wider gamut of entities that play in our financial system. So stock exchanges, insurance companies, payment systems, the parent companies of these entities. The idea was to target all of these entities which could have a knock-on effect in our financial system and bring them under the remit of the FRDI concept. And the way the FRDI bill worked was the idea was to establish something called a resolution corporation, which would initially identify, then monitor, and finally resolve, and if relevant, liquidate a financial firm. The resolution corporation would have, I think, 10 or 11 members, which would have representatives from your RBI, SEBI, IRDA, etc. The idea was the resolution corporation would first identify, using fairly objective criteria, what level the relevant financial institution is in terms of crisis. Starting with low, going up then to moderate, and finally going up to critical. And the idea was that at the lower levels of crisis, low, moderate, etc., the resolution corporation would do things like investigate, monitor, assist, advise, but not take over, right? The powers, of course, of the resolution corporation were broad. In fact, very broad. The idea would be it could stop business, start businesses, it could remove management, it could seek resolution strategies, it could implement resolution strategies, and eventually it could also liquidate. So the powers were broad, but the idea was it would be a step-by-step process. And they could come in when they saw low risk and hopefully resolve that and move away. But if low went to moderate, etc., and went eventually to critical, that's when they would step in. And they would step in and effectively take over administration of the entire firm. The idea was they would have about 1 year to resolve the crisis, and if not possible within the year, extend it to another year. But after 2 years, the financial firm would have to be liquidated. And during that year, the idea was to resolve it, right? They could shut down businesses. They could continue to push some businesses. They could resolve by selling assets, by having a bail-in, which effectively means debt is converted into equity, broadly speaking. They could have a merger. They could have what they call a bridge financial firm, where they move some of the good assets out and let that run separately, and then resolve the bad assets separately. So lots of strategies available to the resolution corporation to resolve the crisis in the financial firm. The most important to you and me, speaking personally, would be what happens to deposits. And the resolution corporation was also tasked with the job of providing deposit guarantee. Of course, the deposit guarantee wouldn't be for necessarily the entire amount of deposits. It would be for a certain limit. For various reasons, the FRDI bill hasn't gone through. And therefore, we don't technically have a mechanism to resolve financial firms, because you'll remember when the IBC came in, the BLRC, which is the Bankruptcy Law Reform Committee, was quite clear in terms of the fact that when it comes to financial service firms, a different law was going to take care of it, and therefore financial service firms were effectively excluded from the IBC. That is very clear in the IBC at the BLRC stage and even in the actual law. And therefore we had an insolvency law which very clearly excluded financial service entities. In fact, there's a definition, if you see it in the code, a long list, an inclusive list of financial services which cannot be covered by the IBC. And in the initial years of the IBC, there were a few cases which talked about what this list meant, how this was to be interpreted. And in fact, the interpretation was pretty wide. So it was not limited to the financial services specifically listed in the IBC. But I think the court said that that's an inclusive list. And frankly, even if you simply have a registration with a financial service provider, that may be enough to take you outside the ambit of the IBC, which is all fine and good. But I think what happened was the stress in the financial firms was not going to wait for the FRDI bill to come through. And so when things tipped over at ILNFS, the government had to take a call. The call taken then, as you're all aware, and Amita will talk about in a little more detail later today, is that the provisions of the Companies Act were used to take over the company. With the help of the NCLAT, a moratorium was imposed. And the mechanism used to resolve INFS was a bit of what you would call effective cherry picking, right? Because you had the benefit of the Companies Act, you had the benefit of the NCLAT moratorium, you had also a suggestion that the principles, the broad principles of the IBC would be used to help resolve the ILNFS matter. And I think the ILNFS matter, and Amita will go into a few more stats later, has been reasonably successful. I think they've used and cherry-picked many of the IBC concepts where useful. Where not, they've applied their own principles. For instance, in relation to the distribution formula, they have stayed away from the strict 53 IBC formula. And many other deviations as they've gone along. But I suppose we reached a situation where that was a model which obviously took a lot of input from the MCA, for instance, because the MCA was effectively running the show in many senses. It was the nodal ministry which applied the Companies Act sections to take ILNFS into IBC. And also, it was a system which seemed to work for ILNFS, but query whether it would work on an ongoing basis for other FSPs. And therefore, I think when the next financial institution came knocking on the doors of insolvency, which was Dewan Housing, and not least because of the alleged fraud that had happened in that company, the suggestion was maybe we use the IBC with certain tweaks to apply to even a financial institution insolvency. And that's something my partner Avinash will speak about later today. In hindsight, it seems to have gone off very well. Creditors made a very effective recovery. The business was handled very effectively during the insolvency process. Creditors got a reasonable recovery. Some would call it an above average recovery. And all in all, that company has been effectively resolved and is, its assets are continuing in the hands of Peramal, the successful bidder. And therefore, with that suggestion came in, amendments to the law, new rules called the FSP rules, which were brought in to bring in, on an ad hoc basis, financial institutions into the sphere of the IBC. And so broadly, the FSP rules came in to allow regulators only, mind you, not your average creditor. Regulators only to take a financial institution of a certain category into IBC. And effectively, if you think about it, there are 4 or 5 differences that the FSP rules bring out in relation to a financial services IBC versus a non-financial firm IBC. Now, there are a lot of practical differences, which each of us will go into when we talk about these cases. But broadly, if you think about what the FSP rules has identified is the moratorium, for instance, right? In a non-financial firm, the moratorium kicks in on admission. But that would not work for a financial firm, right? If you think about it, the very fact that a regulator has taken a financial firm into IBC or filed for it means there'll be panic in the markets. And if there's panic in the markets, there could be a run and there could be enforcements, there could be an ineffective pull out of assets from the financial firm, which could reduce the chances of its resolution. And therefore, it was important to have a moratorium kick off right at the beginning of the process, i.e. on filing rather than admission. So that's one key difference. The second difference, obviously, is the fact that only a regulator can pull it in, and it's not an average creditor that can pull it into IBC. Then thirdly, any resolution plan would also need to be approved by the relevant regulator, which again, if you think about it, makes sense. There is also the requirement that the registration that the financial firm has with the relevant regulator continues during the process, because obviously any bidder is looking for that license, right? I mean, there's no point only buying the assets. It's not an asset sale, it's a business sale as a going concern. So that license with the financial regulator also continues throughout the IBC process. And then very importantly, actually, there's a concept of financial service firms, third-party assets, which, sorry, just give me a second. Very important concept of third-party assets, because if you think about it, as a financial service provider, many of these institutions hold assets effectively in trust for third parties, right? When you go and keep your jewelry in a locker in a bank, that jewelry is not the bank's. That jewelry is actually yours. It's not even the same as putting cash in the bank, right? Because in a sense, when you put cash in the bank as a deposit, it sort of becomes the bank's asset, and they simply have a liability to you to repay that amount, which is different from your jewelry, because that jewelry cannot be commingled. It can't be that you put in a necklace in the vault and that becomes part of their assets, and they can mix it up and give you some other necklace when you go back. So this is really very much your asset. And I'm taking an everyday example, but that goes much broader, right? There could be many such assets, financial assets even, where the bank actually holds it for third parties. And this is a broad understanding of what third-party assets is, and the rules made clear that this falls outside the liquidation estate. And your resolution of the financial firm will not touch on these assets, which have to be handed back to the actual owners. I think that's about the differences, the broad differences from the rules perspective between a financial services insolvency and a non-financial firm insolvency. And I think I should, without further ado, hand over to my partner, Avinash Amrita, whichever you guys are taking it first, to run through what we experienced when we ran each of these 4 cases. Of course, as I said before, ILNFS was a little bit from the outside, from the investor perspective, because we advise a number of investors to help invest and help resolve some of the companies in the ILNFS kingdom, so to speak. And then, of course, the other 3, we represented the RBI and then the administrator. So that's a much more of an in-depth, inside look that we had, which we'll talk about. I think we have about half an hour done. We have 3 hours for the session. Maybe we talk for, Mr. Batra, maybe we talk for about another half an hour, 40 minutes, you think, each, and then hand over to questions? Or shall I pause right now for questions as well?
It might be a good idea, to let people ask some questions this stage if they have on a broad framework and everything. Although, of course, I am sure that when you go through the presentation, they may have more specific questions. I just and Nilang, if and before you call upon people, and I'll also defer to Radhika with what Radhika feels about it, what stage we should leave the questions to. I just wanted to make 2-3 observations in order to sort of just amplify a couple of points that you made or to supplement them. But before I do that, I think it's important for all the participants to understand that you, of course, have been very hands-on with the transactions, as you mentioned in all the 4 cases in particular. And we have been advising, I've been advising a few players here and then in almost all the 4 cases. And it's a delicate thing for us to be able to share every single detail, to be able to talk about everything, or to be able to, answer every question that may come. So I just thought that it might be important to mention that, so that our participants know that we may have certain constraints in terms of what we may be able to answer, what we may be able to say or not say. The 2 observations that I had was broadly that this is again one of the very successful experiments that we have done in India, and it happened quite unexpectedly. It was, as Nilang also mentioned, not really something which was thought through in the initial stages of IBC. But when the need was felt, the policymakers stepped in and made it happen, and we've had quite a successful journey so far in that front as well. And there are learnings that, of course, one would take back home and continue to improve. The second is that we do understand that even in the financial services insolvency space, the expertise is quite limited in terms of people who can add value to the process. And as the space opens up for more enterprises to be pushed into insolvency in the event the need arises, we will need more and more players going forward who have some or the other role to play in the whole processes. So therefore, I think it's a very useful that the ICSI IP has done by introducing this session, because I think this learning coming in, especially from AZB and their partners who have been very hands-on, is going to be very useful from market knowledge development point of view. And third, quickly, we don't know how though things will pan out in the future as well. As we have the bank insolvency law in whatever name and shape coming in future, there might be an argument that it should be a subset of that rather than here because of the similarities in the process. But that is, of course, something which is a bridge that we'll cross when we come to that. Although there seems to be already a merit in continuing to let it sit where it is at the moment because of the way it has worked. And there are encouraging signs that it might just be more. But why I'm saying this is because, the whole framework for the two might be different. You may have you'll have different regulators, different rules, different regulations. And therefore, this becomes a very important issue as to where this would ultimately sit, in which vehicle, which framework, under what regulator, and what kind of rules will apply to it going forward. So these were some of the comments that I just wanted to mention in order to provide a futuristic perspective to this. So that we have a kind of a holistic view of things in the long. And so now, maybe Radhika, if you would like to tell us, should we take questions now or leave it to later at the end? You're mute, Radhika.
So we can take afterwards.
Okay, very well. Nilang, then in that case, I suggest we proceed.
Should we start with ILNFS?
Sure, yeah, please, absolutely. That's probably also chronologically correct.
Yeah. That's fine, Mr. Batra, right?
Yeah, yes, absolutely fine, absolutely fine.
Great. So I'm going to go into some numbers, but I'm not going to go into too many statistics. I just want to I just think the ILNFS case is actually very interesting, not least because of the peculiarities that came with the ILNFS group and so on and so forth, and to understand what went down in ILNFS and what is going down in ILNFS. I think it's very important to understand why ILNFS is something of an outlier even when it comes to financial sector entities as a whole. So I think one thing we need to talk about is timing, because it happened in 2018, just when IBC had come in, and as Nilang mentioned, there wasn't really a framework for resolution of financial service providers within the IBC. The second thing I think that was crucial was the urgency with which it had to be addressed. And that sort of flows from the systemic importance of ILNFS. Just to give you a sense of what ILNFS was, what the regulators, the stakeholders were looking at. ILNFS is something of a giant when it comes to most conglomerates in any case. So you have one holding company, which then has 14 intermediaries, each of which is spread across diverse sectors. And I'll go into the diversity of the sectors separately. And then there are about 300 operating companies. So we're basically looking at a universe of over 300 companies that needed to be resolved, and that needed a framework that would support a group of that magnitude, and therefore implications of that magnitude. Even among the operating companies, I think, if I'm not wrong, there were around 120, 130 offshore companies. So that came with their ancillary issues of resolution outside of India, and 174 were domestic. In terms of sectors, we were broadly looking at, if I'm not wrong, 12 to 14 odd sectors, which of course had financial services, which was a crucial sector from a public interest perspective to begin with. Then there was transportation, energy, maritime, education, waste management and environmental services, IT, urban development, water, engineering and construction, and real estate. So pretty crucial sectors in terms of what might have an impact on public interest, as we lawyers and very often judges also like to call it. The third very, very important factor that played a role, not just in the commencement of the proceedings or in terms of setting what the process would be like, but also as we go along in the litigations that happened and in the new distribution framework that was introduced, was the quantum of public money involved or at stake. Financial sector as it stands is something that any resolution or upset in the financial sector or in financial sector services firms is likely to have a wide-ranging effect as far as the public is concerned. But particularly with regard to ILNFS, the amount of public money that was at stake was a significant amount. I think in terms of numbers, where the total group debt was around 99,000, a little less than 99,000 crores. It's been reported that the amount of money that was owed to public financial institutions and other financial institutions was around 2/3 of that. So it was around 60 crores or a little south of 60 crores, if I'm not wrong. So what happened? What went wrong? There were defaults which started in 2018, September, which led to a decline in the credit rating and which sort of set off all sorts of alarm bells. The concern here was primarily of mismanagement in terms of why the company was or why the group was finding itself in the amount of stress that it was in. The central government then made an application under Section 241 and 242 of the Companies Act. What are 241 and 242? They're essentially sections on oppression and mismanagement. They give very wide-ranging powers to the tribunal because they are to be called upon in situations of particular outlier situations of gravity, of significant gravity, which this seemed to be, in that they had found the debt to equity ratio. I think it's been reported in one of the places to be a 10:1 ratio. There was massive asset liability mismatches, cost overruns in most projects that they were involved in. Why Companies Act and why not IBC? That's something Nilang's already touched upon. But I think the only thing I'd add to that is because ILNFS, unlike the other financial sector, or potentially what would have been construed to be a financial services firm in resolution, was not just in the financial services sector. It's a conglomerate that's like I mentioned, spread across 12 to 14 different sectors to begin with. And given the magnitude of it, in my opinion, it's not something that should be clubbed together with a financial sector insolvency because of the peculiarities and because of the nuances that I think are specific to the ILNFS sector, ILNFS group as it stands. So what does the NCLT do then? The NCLT essentially passed orders under section 241 and 242, which basically replaced the board of ILNFS, and it brought in a new board. Consequently, the new board needed some protections to make sure that they would not be held liable for the past actions of the old board, which is why a move was made to make sure that those directors who came in, who were I think in a significant number of cases, they were stalwarts in India's business sector in any case, who were actually volunteering to sort of step into a situation which would have otherwise blown into a massive disaster as far as the Indian corporate sector was concerned. There was a move to make sure that they are protected against any past actions and that they have the independence to step in and take those hard calls that they had to make to resolve a group of this magnitude. The third thing that came in was a moratorium. Now, we have to be conscious here that the IBC was technically not available for an action under the Companies Act, which is why it was a little problematic to sort of conjure up a moratorium under a scheme that doesn't otherwise contemplate it. Naturally, it was litigated in that most creditors would not be very happy with a moratorium. It went up to the NCLAT, and the NCLAT on appeal approved the moratorium. It's interesting to keep in mind that the NCLT had not awarded the moratorium, and it was at the NCLAT stage that the moratorium was awarded. It was awarded under a residual section for all practical purposes under 242 of the Companies Act, which basically says that the tribunal can take such other action as it may deem fit in public interest. Why was it important to have this moratorium? How was it justified? One aspect, of course, was that status quo is very important when you're resolving a company, particularly to stop the multitude of cases that will otherwise crop up the minute there is some level of distress. The other issue was the deeply interconnected nature of these 300 odd companies that we're talking about, which where proceedings in one would necessarily have an impact on proceedings in the other. You sort of transpose this into a scenario where most of these companies were spread across various jurisdictions in India, and you'd have hundreds of cases, more than hundreds of cases coming up in various NCLTs, which were effectively a part of a resolution, or which should have been a part of a resolution, which should have been a collaborative and a consolidated process. The third very practical concern that was flagged was that the NCLTs across these various jurisdictions would then be overwhelmed by the number of cases that would come up, with each SPV being taken through an IBC process, and therefore having interim orders or interim applications come in to consolidate those, and so on and so forth. Again, keeping in mind that India back then and today as well doesn't really have a group insolvency framework, which is set out under the legislations. So this was what the NCLT ordered. In addition to that, there is a very interesting aspect in what emerged through the proceedings, which was a distribution framework that actually deviates a little bit from Section 53 of the IBC. Initially, the proposal was to stick to Section 53 as far as the distribution to the creditors was concerned. But this, of course, underwent a bit of a change because of the peculiarities of the ILNFS group. And I will go into this a little later, because this is one of the most interesting factors of the ILNFS story. I should mention that the NCLAT's orders are pending Supreme Court's determination as far as an appeal is concerned on this NCLAT order of 2020. Before I go into how the resolution would happen, I think it's important to talk a little bit about a scheme that the new board introduced that was approved by the NCLT about what would happen while the resolution process was taking place. Again, I think this is quite peculiar to ILNFS, but is a learning that can probably be picked up in terms of group insolvency. Other group insolvencies that come up in future, if at all India were to introduce a regime. In that, what the board did and what the company did was basically classify the subsidiary companies or the group companies or operating companies within the realm into three categories. Green companies, which could service their debt. They had the cash flows to support payments that they needed to make. These green companies were allowed to pay off their debt in a timely manner. There was no restriction on them making payments. Amber companies, which could service operational debt and could service senior secured debt. And red companies, which could not even service senior secured debt. Now, amber and red have something in common in that they couldn't, based on their cash flows, it was projected that they would not be able to service all of their debt. And therefore, amber and red were effectively subject to a regime which only allowed them to make going concern payments, i.e. payments required to be made in order to retain them as going concern entities. And therefore, effectively, for an ILNFS group company, the first question you'd ask yourself is, am I green, am I amber, am I red? Depending on where I fall in these three classifications, essentially, you'd be able to answer the question as to whether I can make a payment before I have been resolved or not. And what kind of payment can I make? In case of amber and red, you'd have to answer this you'd have to be able to identify this payment as a payment necessary to be made in order to maintain the company's status as a going concern. In green companies, all bets were off. So the lenders of the green companies got lucky. This classification was based on a 12-month cash flow based solvency test. So it was something of a sort of a projection. Now, what I should have mentioned was, and I did mention that this started in September 2018, but the cutoff date for the moratorium was October 2018, if I'm not wrong. So we are 4.5 years from there. A lot of things changed as we went along those 4.5 years. One of those was a move to shift some of the amber and red companies from the amber and red classification into green. Why would we want to do this? Because the creditors might say that the company is healthy, it's doing well. There's no reason as to why you're stopping the company from servicing the debt owed to me. And therefore classify this company, which you had thus far classified as amber or red, into green, so that the company is then allowed to make regular payments to its creditors. There were some instances where this happened, and the way the participants went about doing this was essentially, and this is, there was no particular scheme set down for it, but this is sort of more anecdotal based on judicial precedents or judicial pronouncements for various companies that were announced. But the suggestion seems to be that the first step was to agree to some form of a restructuring with the lenders and to sign a term sheet or some such, which would essentially allow the lenders to agree on a repayment schedule which was more in line with the cash flows, and then enter into binding documentation, and then approve then approach the NCLT for approval to de-categorize or recategorize the company into green again. I suspect one of the reasons as to why some companies which continued to do very well were not classified as green despite that was primarily because this included an element of negotiation as to what the restructured terms of the debt would be, and often that might have been a tricky sort of negotiating point to arrive at a conclusion at. So that's what would happen to companies while they were being resolved. How would they go about being resolved? A bunch of solutions were thought of, and I think each of those reports that have been released by the ILNFS's board and have been submitted in affidavits and so on and so forth acknowledge one key factor, in that there is literally no one size fits all which works for all companies or which will work for all companies within the group, which is why there was need to introduce some amount of flexibility as to what the board would deem to be the best way to deal with it. One of the things is the recategorization of companies into say amber and then back into green, right? Because that does involve a certain degree of flexibility that is required from the position adopted in 2018, and requires essentially the stakeholders to agree to an alternative path to take to resolution, not necessarily a completely different path, but an alternate path with the approval of the NCLT. The one mode of resolution that we've seen used and that we've frankly assisted with also is essentially asset monetization. So each asset within the group, so each asset being each SPV or each operating company, would effectively be sold, and the proceeds of that sale would then be distributed. This is a sort of a 30,000 feet view of what would happen if it were asset monetization. Another alternative which was explored was a business vertical monetization. So as I mentioned, ILNFS is one holdco with multiple subsidiaries below that, which are intermediate companies, which are segregated based on the operations that their subsidiaries would undertake. So for instance, you have ILNFS, which is the holdco, and then you have ITNL, which is ILNFS Transportation Networks Limited, which is the intermediate company for all transportation companies. And then below that are your SPVs, which are project companies, which undertake road projects and so on and so forth. So the idea was to monetize the last level, which is the operating company level. How would they go about doing this? Very quick sort of an overview. Essentially quite similar to the IBC process in that EOIs were invited. There was a valuation done to a certain the liquidation value and the fair value of the company. They would invite bidders to do a diligence. The bidders would submit a bid. And this is where you deviate from the IBC. The bidders would submit a bid to the board, to the new board of ILNFS. The board would then select the highest bid. Now, once the highest bid has been selected, then the company would be categorized again in one of two categories. If the bidder, essentially the winning bidder, so to speak, but he's not won as yet. So the potential winning bidder, let's call him that. If the potential winning bidder agrees to assume all the liabilities of the SPV, then effectively this company would be categorized as category 1. Now, what does category 1 mean? Category 1 means that the COC of category 1 will not be the creditors of the SPV. It will be the creditors of the selling shareholder. So in the example I gave you, so if there's ILNFS, there's ITNL below ILNFS, and then there is, let's say, SPV. If for SPV you got a bid, where the bidder is saying that the debt at the SPV level is something that the bidder is going to assume. That means that the proceeds of the share sale that will come in will effectively go to ITNL, which is the holding company, and essentially will be distributed amongst the creditors of ITNL, which is why the COC in such companies, in category 1 companies, would have been formed by the creditors of the selling shareholder. Category 2 was where the bid value that was given was below the quantum of debt at the SPV level. So there was a risk, or rather there was a likelihood or almost a certainty that the creditors at the SPV level would not get paid out, which is why they had to have a say in what would go down. So therefore, the COC for category 2 companies, where the bid value was below the value of the debt at the SPV level, would be constituted by the creditors of the SPV. And by creditors in both cases, I mean financial creditors. Now, this in and of itself is a deviation from the IBC, but one of the key factors that sort of set it apart was that, unlike the IBC, which doesn't allow related party financial creditors to bid to participate in the COC, in ILNFS, in the process, there was no such restriction on related party creditors from being a part of the COC. By related, again, I mean related party financial creditors from being a part of the COC. So essentially, the COC would effectively, in most cases, be formed by external debt or holders of external debt, as they call it. So creditors of companies who are, or rather creditors who are not ILNFS group companies, and to a substantial extent by ILNFS group companies who are lenders to the SPV. Because the model that had thus far been followed for the purposes of debt raising was that there would be debt raised at the holdco levels and at the intermediate holdco levels, which would be passed down by way of very often subordinated debt. And there would be debt raised at the SPV level as well. But we'll go into this in a little more detail when we go into the distribution mechanics. The COC then votes with a 2/3 majority to either approve the plan or approve the proposal or not. The new board and then retired Justice D.K. Jain were basically going to consider the proposal to see whether it makes sense. And then the last step would be to get NCLT approval for the proposal. Once NCLT approval has been obtained, that's when we get to the interesting part, which is the share sale occurs, the money comes in, and then we go into distribution. Now, as I mentioned, the previous plan, as far as ILNFS was concerned, was to stick to Section 53 distribution. What would this mean at an SPV level? let's say at an SPV level, I have a bunch of senior secured debt, which the value of which is the same as the liquidation value of the company, or is a significant amount, but is sufficient to be discharged by the value of the company itself. The first outflow would have been towards process related costs, which is what it is. The second outflow would have been towards secured creditors along with workmen. At that point, in most cases, would be the point at which the money would run out, which is why the unsecured creditors or the subordinate creditors would most likely not get a part of, or even a significant part of the pie. Who does this trouble massively? It troubles the shareholder debt that had come in, which was in most cases subordinated and unsecured. Why does this create a public interest issue? Because the ultimate holder of that debt, or the ultimate creditor of that debt, would have been, or was in fact likely, a whole host of public sector banks and a whole host of pension funds, welfare funds, welfare groups, both in terms of the armed forces, in terms of gratuity, in terms of possibly every sort of public what should I say, every sort of investor that was counting on a great degree of certainty as far as their returns was concerned, and the lack of certainty would impact the masses, so to speak. Now, these were the categories of lenders who had lent at the intermediate company level, and this money had then been on lent to the SPV. So if we followed 53 as it stood, it was very unlikely that the sale at the SPV level would result in a significant return to the holdco, and therefore to the creditors of the holdco, which wasn't an ideal scenario given the public interest involved, given the stakes involved at the holdco level, and equally given the fact that the holdco, once each of these sales, so to speak, were concluded, the holdco wouldn't have too many assets left to sort of service its own debt, which is why an alternate to Section 53 was sort of introduced, which essentially said that the waterfall would be as follows. Level 1 would be cost related to the process, which is the same as Section 53. Level 2 would be distribution of an amount equivalent to the liquidation value of the company, which is to be distributed as per 53 to the extent of the creditor's average liquidation value. So if let's say that the liquidation value of a company is let's say 1,000 crores. The total debt of the company is, let's say, 1,800 crores. And the bid value that's come in is, let's say, about 1,500 crores. What happens is that up to 1,500, the first outflow is towards costs and expenses. Let's say for a minute that the process costs are nil, just for the sake of argument. Liquidation value up to 1,000 crores would then be distributed as per Section 53. So then the priority set out in 53 is honored. The creditors of the SPV are relatively happy, assuming that they're senior secured creditors. So they've acted prudently as far as lending to the SPV is concerned. What remains is 500 crores, right? Because the bidder is willing to pay 1,500 crores. So as far as the 1,500 crores are concerned, so as far as the 1,500 crores are concerned, 1,000 crores is out, 500 crores is then distributed on a pro rata basis amongst all creditors based on their outstanding claims. So this is where those creditors who otherwise would have been lower in the rung as far as Section 53 are concerned, effectively get a pro rata piece of the distributions along with the secured creditors. So this was essentially the IL&FS distribution model that's sort of been in a form sort of been discussed in the MCA discussion paper which has been released about a month, if I'm not wrong, ago as well, but more on that later. Another route that was observed was specific to road assets, because because ITNL was a large chunk of the pie, and ITNL came up with a very interesting concept. ITNL is IL&FS Transportation Networks Limited. They came up with a proposal where they'd set up an InvIT, and essentially they would transfer the shares of certain of their SPVs to this InvIT. And once the shares had been transferred, then the InvIT as it stands would, the SPV now under the control of the InvIT would continue to service its debt, often presumably with a certain degree of restructuring. This has also been quite interesting. It has been used in the past, in that about 6 of the SPVs have been transferred as of 2021 to the InvIT. Some are now waiting to be transferred, waiting for NCLT approval or government approval, where it's a JV between ILNFS and the government. Especially when it comes to road assets, there are a fair number of regulatory approvals that need to be sort of grappled with when you're talking about a change of control of a road company. Not the least of which is the NHAI's approval. So there is, I suppose there is a lag time that is to be expected when you're talking about a resolution of such a company. So this is another mode that was sort of deployed to resolve, or is being deployed to resolve road transportation network companies, or ITNL companies, so to speak, which we've also heard has been used pretty successfully, or at least pretty enthusiastically in the past by creditors. So where are we today? Which is a tricky question always to answer under these circumstances. We are, as I said, 4.5 years from when this all started. So we sort of very practical and often a little bleak position to sort of approach this, or a bleak view is that we are at a stage where there are a fair few companies which have not been resolved, which have a set of some displeased creditors who've been waiting for 4.5 years basically to get a payout. Let me start with the good part though. What we understand is about 57,000 crores worth of debt has been resolved. 101 companies have been resolved. What remains is 90 domestic companies and 13 offshore companies. This is an optimistic number, and I'll tell you why. The reason is that this includes those cases which are either pending NCLT approval, or they've got NCLT approval and are pending closure. Why is this a little optimistic? Because not in terms of certainty, but in terms of the fact that we're not there yet in terms of timing. Most of these companies will require a fair few regulatory approvals. Their sale transactions will never be as straightforward as to not have any CPs, so as to have a complete share transfer as soon as it happens. And in most cases, when the debt is not fully resolved, you will be looking at negotiations with lenders to restructure the debt and so on and so forth. This also doesn't include those companies which have been classified as green, naturally so, because those companies are continuing to service their debt. Why is it that we are, what have we seen in terms of the sentiment of the creditors? A lot of the lenders that we have either interacted with or we've heard from, not necessarily represented, but the ones who reach out to us on ILNFS generally, are concerned about a couple of things, right? One is the distribution mechanism puts them in a relatively, in a position of disadvantage as compared to 53 having been followed, assuming that they are SPV lenders. Because most SPV lenders will have prior security as far as the SPV assets are concerned, and would have lent on the basis of the assumption that their debt would always be paid out before the shareholder debt is paid out, which is a credit call that has been sort of flipped over with the new distribution mechanism. Not entirely, but to a large extent. Two is that the reliance on this liquidation value itself has been a little problematic, because you're talking about a number that was agreed to 4.5 years ago. Things have changed in the last 4.5 years. Some companies have been doing well. Some companies have a lot of cash sitting in the account, and there really isn't any reason to now hold on to that liquidation value number that was 4.5 years old. The third, which is a major bugbear, is that for 4.5 years, the debt has not been serviced. It's not earned interest. It's kind of stuck in a limbo. So are these problems novel to ILNFS? Not necessarily. Is the time taken something that's going to be an issue? Naturally, as is the case in any other insolvency. Could it have been done quicker is I suppose a question no one can really answer, but it certainly is a very bespoke plan to resolve what I suspect would have taken much longer had it not been consolidated and brought together. What should we learn from this? I suppose one thing to learn from this is that there is significant merit in a process that treats interconnected companies and groups, for the lack of a better term, that gives the option of treating them under a bespoke, not necessarily a bespoke, but a tailored process for group insolvency, which certainly would move things along. What I would be interested to learning from to hearing from you guys on is given the peculiarities that you've heard of, the distribution mechanism that has been introduced seems to be something that was tailored for ILNFS. Would it work in a non-ILNFS situation? Would it be advisable in a non-ILNFS situation? Obviously, it has its merits in that it sort of gives a decentish payout, a better payout to non-secured financial creditors, so to speak, who have been getting an advantage as far as 53 is concerned. And that seems to have been the legislative intent as well. That was the position in the 56 and 2013 Companies Act as well. But to elevate this class, which is unsecured creditors, which is to a certain extent trade creditors as well, is this something that one should be exploring as far as IBC, general IBC is concerned, given your experience, or do you think that there might be some that this was something that was specific to ILNFS and is not something that needs to be explored to sort of rock the apple cart as we have under the IBC? So I'd be very keen to hear your views on that, but happy to take any questions that you may have.
Participants can ask the questions from Ms. Amrita. Anyone having any questions, they can ask.
I think as is done in IBC cases, so there has to be an early identification and then action on financial stress. So that is what is needed, even if it is a case of group insolvency. That is one of the learnings that we take it from here.
Absolutely. No, makes sense. I fully agree. And I don't know how much of it could have been solved by early identification, though as far as ILNFS is concerned, it was only after there had been defaults that steps were taken. I agree with you in that early identification is absolutely crucial, but I think one thing that might supplement it is an introduction of better governance norms, or rather both at the company level and at the sectoral level, to ensure that things like asset liability mismatch and over leveraging and cost overruns and so on and so forth are identified and reported amongst the shareholders. We already have the laws, frankly. It's a question of implementation and stringent implementation. And I would like to believe that after ILNFS, the RBI at least has been very proactive in sort of firmly encouraging its entities to observe corporate governance norms.
I think ILNFS is a case wherein probably the entire water was muddied.
Yeah, I suppose, as far as ILNFS is concerned, a lot went wrong, and there was so much to have gone wrong given the size of the group, given the diversity of their exposures, given the way they did business in that day. Raising debt at the intermediate level and then pushing it down and so on and so forth. It's difficult. I wouldn't want to go out on a limb to say who did the muddying of the waters, but I agree in that what the new board inherited was a mighty mess. So to have arrived at something that made sense, to have arrived at something that now sees 101 companies resolved is great news. Is commendable, is definitely commendable, and we have a lot to learn from it.
Okay, another thing, as in legal parlance, we say extreme cases made bad law, right? So would you say the same thing in this case also? So was it an extreme case in terms of the size of the group, or and probably the result that we have in terms of the law was extreme? What is your going to be the conclusion?
I would say it was an extreme case. I don't think we can argue against the fact that it was an extreme case. Do we have a comparable scenario? Off the top of my head, I can't think of another group that would tick all the boxes in terms of comparison with ILNFS. Do extreme cases make bad law? I agree that that often legislations can be a reaction, or judicial pronouncements can be a reaction to an outlier situation, which perhaps may need to be tempered to the median as opposed to that outlier situation. But that said, under the circumstances, as far as ILNFS is concerned, there wasn't, because ILNFS was under the Companies Act and because it was not under the IBC, in terms of setting precedent value as far as the ILNFS cases were concerned, I think they'd be helpful to address issues which don't squarely fit within the IBC, so to speak, or to justify supplementing the IBC to whether it's in the area of group
papers from MCA. Hello.
Hi.
Am I audible, Amrita? No.
I can hear you now.
Voice is distorted. Yeah, I think.
Can you hear me?
Yeah, I can hear you now.
I can hear you, sir.
Yeah. Spoke about some discussion paper from MCA. This discussion paper is centered around this
Sorry, sir, I've lost you.
Some opinion formation that whether this kind for other cases as well.
Sorry, I didn't catch the question. I think, let me just try and switch off my video and see if
No, Mr. Kabir, I think there was there's some issue in your internet side, I think. Please, if you could just repeat the question.
Am I audible now, Amrita? I think, yeah, I just asked, sir, that there is a discussion paper Amrita mentioned.
So your voice is not audible. It's advisable if you can just write in the chat box your question. So we are not able to hear you.
Yeah, I will put it on a chat box. I think there is a
so
problem
if you're
with
asking
internet
about
connection.
the discussion paper, I'll spend about a couple of minutes on it. Essentially, the MCA has introduced a discussion paper for some changes that they propose to bring into the IBC in January 2023. One of the changes that's been proposed, and these are just changes that on which they've invited public comments, is that they will amend the code to provide a more equitable scheme of distribution of proceeds pursuant to a resolution plan. And this equitable scheme, one of the proposal that the paper talks about is that the creditors will receive proceeds up to the corporate debtors liquidation value for their claims in the order of Section 53. And the surplus will be ratably distributed between all creditors in the ratio of their unsatisfied claims. So to sum up, essentially, a ILNFS-like distribution framework has found its way in the MCA's discussion paper as a point on which MCA is seeking public comments on whether this makes sense to introduce as far as general IBC cases are concerned or not.
Understood. Thank you.
Specifically in the realm of CIRP is the portion I read out to you was as far as waterfall under CIRP is concerned. So again, I think one of the things that all market participants and all those who are going to sort of comment on this paper are going to have to take a view either way on whether this works in general IBC cases or whether it doesn't. And I thought that's an interesting point that I've been grappling with myself.
Okay. Yeah, you also asked the same thing. Yeah. Thank you.
All right.
And another thing, I was a little keen to understand as to how a case of 241, 242 moved to kind of this IBC situation. So how was it taken forward? How did it start?
Oh, so it never moved to IBC. Technically, IBC doesn't apply to ILNFS. As far as the scheme is concerned, ILNFS is being resolved pursuant to an order issued by the NCLT and the NCLAT then under section 241 and 242 which of the Companies Act, which give them very wide-ranging powers. The way this is happening is that there is essentially what they call a resolution framework, which is the process I set out, right? The EOIs and so on and so forth. That process that they've set out, one of the overarching statements they've made is that when we run the process, we are going to keep in mind the principles of IBC. So they've effectively adopted the principles of IBC without being subject to the IBC itself, as far as this process is concerned. Make sense?
Yeah, I got it now. So is it like the principle of res judicata that we have in CPC? So while technically that would not apply, but the principles would always be there.
Yeah, not res judicata so much, I would say, in terms of the idea is not to take ILNFS into IBC again, which is when res judicata would apply. But as far as this is concerned, you're absolutely right in that if I were to, for instance, if I were to set up a COC today to resolve the debt in the company outside of IBC, a bunch of creditors agree that we will enter into an intercreditor agreement. And in that intercreditor agreement, I would say that the meetings of the creditors is going to be held as per the provisions of the CIRP regulations. So I'm importing the procedure or the fundamental principles into my process voluntarily without actually being subject to that process.
I guess no further questions are there, ma'am. Thank you so much.
Thank you.
We can proceed further with the session.
So,
does it
thank
make
you.
sense? Thank
Sorry,
you.
yeah, go ahead.
No, I was just going to say, does it make sense for us to jump onto DHFL now? And thank you for taking that, Avinash. But this was obviously the first of the FSPs that went into IBC. One thing to note is, there's a lot of talk about how IBC cases take a long time to admit. But given the importance of this matter, I think from the time we were instructed by the RBI to the time we went to court was, I think, about 3 days. And then from filing to admission was about a day and a half, just for context in terms of how quickly this moved. And I'm sure Avinash will give you more stats in terms of when it started, when it ended, etc., etc. But I think the short point is this was a model example of how quickly the relevant stakeholders moved to preserve the value, and then thereafter also in terms of resolution, how quickly stakeholders moved, including the courts, to ensure resolution happens. And of course, one can't underestimate the involvement and contribution of Mr. Subramanya Kumar, who was the resolution professional or the administrator of DHFL, who played an absolutely phenomenal role in A, preserving value, B, almost resurrecting the business, from where it was flailing to, and then 3, facilitating a resolution. But sorry, I ramble on. Avinash, over to you.
No, thank you, Nilang. Actually, I think that was a good introduction to what this asset was. I think this asset was to start off was a complicated asset. It is an asset which had a similar asset had never tested the framework of IBC before. So actually putting this asset into IBC was a huge leap of faith by the Reserve Bank of India. It actually showed their confidence in the framework that an asset like DHFL can actually be resolved in a framework given by IBC. And I think it showed the confidence that RBI had with respect to the framework, and the fact that the asset was actually resolved, as less as 18 months, as Nilang was saying, for an asset that is had so many stakeholders in play to actually be resolved in such a quick period was a testament to the fact that IBC as a framework works. It's a question of, there might be certain leakages at different, with respect to different parts of the framework, but as a framework, it is a success with respect to resolving a company and being able to resurrect it, even if it is as complicated an asset as DHFL. So, with just that starting comment, now I'll just dive into giving you firstly a snapshot of what DHFL entailed. So DHFL was one of the largest housing finance companies in India. Its total debt book was close to 1 lakh crores. It had a running business. It was a running business. As early as January of 2019, it was AAA rated. It was downgraded to AA rated sometime in June 2019, but it still had multiple exposure to the public. One was that it was a deposit seeking non-banking financial company. So there were actually public who had provided their deposits for the purposes of return to this NBFC. Such an asset had never gone into IBC before. In addition, DHFL had issued multiple series of debentures, which had been subscribed to not only by institutional investors, it had been subscribed to by a large amount of retail investors. It had also been subscribed to by many provident funds and funds that have national interest, including the Armed Forces Provident Fund. There were multiple stakeholders who had exposure to public, including public sector finance company, financial institutions who had lent quite a more about 87,000 crores of debt to this company. From a timeline perspective, this company, so the RBI had decided to supersede the board of DHFL on November 20th, 2019. So RBI, by virtue of its powers under the Reserve Bank of India Act, which governs all NBFCs which are registered with RBI in India, exercises power to supersede the board and appoint an administrator. The administrator had the powers include both of the board as well as the shareholders. He had the powers to operate the company, manage the company, and instruct the employees, similar to what a resolution professional does. But there are certain distinctions. I think Nilang, when he was starting off, pointed out to the distinctions between what is FSP insolvency as compared to a normal insolvency. One of the key distinction is the role of the administrator. Unlike resolution, while the resolution professional is given certain powers under the IBC, and administrator's powers go beyond that under the provisions of Section 45E. So between the period from the time he's appointed as an administrator until he takes over the powers of a resolution professional after the company is initiated into insolvency, there's a certain period where he is the be all and end all of that company. He has both the powers of the board as well as the shareholders. So as Amrita was mentioning during her presentation, there were multiple frameworks by which a resolution could have been done for this company. One is obviously MCA taking its powers under Section 241, like the way they resolved IL&FS. If you see Section 45 MBA of the Reserve Bank of India Act, Reserve Bank itself has powers to propose a scheme of arrangement for the purposes of resolution of any company if it deems fit in the public interest. Reserve Bank of India could have exercised that power, but it was a confidence being reinforced with respect to the IBC that Reserve Bank of India chose that IBC is the right framework for DHFL to be resolved. As Nilang mentioned, unlike a normal insolvency where a creditor files for insolvency or the corporate debtor itself files for insolvency, the provisions of the IBC require that when it's a financial service provider, it has to be the regulator who has to file for insolvency. So the Reserve Bank of India on November 28th filed for insolvency of DHFL. November 28th of 2019 filed for the insolvency of DHFL before the NCLT Mumbai bench based on the various defaults on financial debt that had been committed by DHFL by then. After the filing of this insolvency petition on December 3, 2019, the insolvency petition was admitted and the RBI appointed administrator, Mr. R. Subramania Kumar, he was appointed as the administrator for FSP. So unlike a normal insolvency process, wherein there's a resolution professional, there's an interim resolution professional who is then appointed as a resolution professional. In case of financial service providers, the powers of the interim resolution professional, the resolution professional, and the liquidator, if that happens, are exercised only by the administrator appointed by RBI, because the powers to appoint an administrator rest with the RBI in terms of the provisions of the RBI Act, and the FSP rules mention that that administrator who has been appointed by RBI will be the person who will act as the IRP, RP, or liquidator for the purposes of the insolvency resolution and for the purpose of IBC. So on account of the statutory provisions, the administrator took charge and acted as the resolution professional for DHFL. Now, the way I will, this is just a snapshot. The total admitted debt of DHFL was 87,000 crores. It finally got resolved by the successful resolution applicant discharging the entire admitted debt in the form of both cash and deferred consideration, which totaled up to around 34,000 crores. All of this in the public domain. It is there written in the NCLT order for approval of the resolution plan of June 7, 2021. While the insolvency resolution process started on December 3, 2019, COVID, of course, happened on March 2020. The process concluded by virtue of the receipt of a NCLT approval on June 7, 2021, and the entire resolution plan submitted by Piramal Capital Housing Finance Limited was implemented on September 29, 2021. So if you see, there was a total timeline of about 20 months from the start of its insolvency until implementation. Within this 20-month period, it was an action-packed period. There were multiple issues that came up at multiple points of time, litigations which are still continuing, and therefore I will not be able to comment upon the litigations myself because they are currently also pending. Various litigations are pending at various forums. I can, of course, give you the facts for the purposes of this forum's understanding. I have, since this is, we want to pack this session into a 40-minute session and then open the forum for the purposes of questions. We divided the main points of discussion that happened during the DHFL process, which is to the extent available on public domain. I will be able to cite facts as well, into 9 different discussion points. I will spend about 3 to 4 minutes on each of these points. So we should be able to cover it over the period that we have available right now. And at the end of the covering those 9 points, I will, we can then open up the forum for discussion and for Q&As. So the first point that was of uniqueness to the DHFL resolution process was, unlike a normal IBC, what happens during a normal IBC is that once the insolvency resolution process is admitted, the powers of the board are suspended. Once the powers of the board are suspended, those powers are then exercised by the resolution professional. However, I'm sure all the resolution professionals over here would be aware of the various Supreme Court decisions that have come about, wherein directors are required to continue attending the COC meetings. They get access to all the documents that are discussed in a COC meeting, including the resolution plan. They're required to comment upon those resolution plans. Their views are supposed to be recorded in the COC meeting. and they are also offered an opportunity. This has, it has both pros and cons. Of course, pros being that the directors who have been in charge of the company know more about the company and are therefore able to assist the resolution professional with respect to operation of the company. The con being that it leads to unnecessary litigations where potentially confidential documents are made available to directors who may not act in the best interest of the resolution of the company. A unique aspect of the DHFL process was that, unlike a suspension of board of directors, in case of DHFL, since the board of DHFL was superseded, and it was not superseded by any provision which is contained in the IBC. It was superseded by the powers of RBI contained under Section 45IE of the Reserve Bank of India Act. Now, this supersession occurred not during the IBC. It occurred on November 28, 2019, when RBI appointed the administrator to exercise the powers and duties of the shareholders and board, and therefore superseded the entire board of directors. So therefore, when the company had gone into insolvency on December 3, 2019, no director was actually on the board of the company. The board of the company was just the administrator, and therefore the provisions of Section 24, which deal with who are the participants of a COC, when it dealt with the fact that the nominees of the authorized representatives of the board of directors can also attend, that was not considered to be applicable to a FSP whose board had been superseded, and therefore those parties who, of course, the erstwhile promoters did claim that this provision is no different from the provisions of Section 24 for a normal IBC process. And there is Supreme Court judgment. I think there's a very famous Supreme Court judgment of Mr. Vijay Kumar Jain versus the RP of Ruchi Soya, which was settled in the Supreme Court, wherein Supreme Court held that the directors have the power. This was one of the main cases cited on behalf of the promoters to be able to be attending the COC and getting access to the COC documents. However, unlike a normal CRP process wherein the Supreme Court judgment would be applicable, in this case, it was in the case of an FSP, it was settled that the board of directors have lost their locus, have lost their ability to enter the COC on account of their supersession and on account of no longer continuing on the board of directors of the company. And therefore, they do not get the right to sit in the COC vis-a-vis as compared to a normal CRP process where they get the ability to sit in the CRP. So this is the first point of distinction. This, of course, this question was debated at NCLT. You will see an order of NCLT which said what exactly what I'm saying, that NCLT said that this is different, yes, and therefore they do not have the right. And when it went on appeal, it was settled on appeal as well by NCLAT that yes, what the NCLT decision of creating a distinction between an FSP insolvency as compared to a normal insolvency is right. And therefore the directors in case of an FSP do not have the right to attend a COC meeting on account of them no longer being directors of the company. So as the first point of distinction, I'll just move on to my second point, which is actually one of the most important points which is relevant for an FSP. I think Nilang had touched upon this in his initial statements, which is with respect to third-party assets. I think with respect to third-party assets in a normal insolvency process, the understanding is very straightforward. The resolution professional under Section 18 is the interim resolution professional under Section 18 is required to take custody and control of all assets of the corporate debtor. However, assets of the corporate debtor has been defined to exclude any third-party assets. Therefore, there was certain clarity that a corporate debtor does not take control and custody of assets which are not belonging to a resolution professional does not take custody and control of assets which are not belonging to the corporate debtor. However, in case of an FSP, right, their business involved taking control and custody of assets, either in the form of security or, as I think Nilang mentioned, in the form of jewelry in your lockers, right? When your business involved actually having custody of assets, does that mean that, I have to give it back? Does it mean that I do no longer take control of those assets? And another, another transaction which is typically undertaken by lenders, right, is securitization. Like, these are regulated entities which undertake securitization, which actually, they might be getting certain assets for the purposes of loans that they have transferred to a third-party entity and are acting simply as collection agents. In such a scenario, do they take custody of it? What do they do to those assets? There was a gray area with respect to the law. Section 18 by itself was not giving comfort to the market with respect to what happens to the assets which are in the custody of a financial service provider. And therefore, a notification was brought out. This was after DHFL had gotten admitted into insolvency, and the practical problems that were seen when the company had been admitted in insolvency. There was a requirement to give comfort to the market. There was a requirement to give statutory comfort to the market that third-party assets will continue to be serviced by the financial service provider in the same manner as they would have been serviced if the company had not gone into insolvency, because it's very important for going concern basis. Because, for a financial service provider, it's going concern in most of the times is handling third-party assets. So therefore, this was indeed relevant for a financial service provider to give clarity with respect to handling of these third-party assets, and therefore a third-party asset circular was brought out. This circular essentially handled two things. One was where you're acting as a collection agent. It specifically laid out the administrator's duties with respect to when they're acting as collection agents. So you need to maintain clear demarcation of these assets. These are third-party assets. You need to maintain clear demarcation of these assets in order to keep records as to what is the asset that you collected on a third-party behalf and how have you made those payments in terms of that contract. You are supposed to adhere to the terms of those contracts. And secondly, with respect to third-party assets which do not belong to you but belong to a customer, like exactly what Nilang mentioned, right? They belong to either you have taken it as in possession as a pledgee, or you have taken it in possession as a bailee, or you have taken it in possession as a customer has deposited it with you for the purposes of keeping it in your locker. In these 3-4 instances which are intrinsic to a business of a financial service provider, the statutory comfort was given that these assets will continue to be maintained the way it is being maintained. The contracts will be honored. There will be clear reporting and records kept with respect to these assets and how they have been handled. Very unique to a financial service provider entity. This third-party asset circular is not applicable to any other normal. It's been issued in terms of the FSP rules. It has been issued in terms of the FSP rules, only applicable to FSPs, and very unique to a financial service provider on account of which in recognition of their unique business model, which is not typically reflected across all other companies which are in insolvency. Now, the third point that I wanted to bring about is the uniqueness of a financial, this is taking forth, this is just a build up to what was, the second point that I discussed, that what is the financial service provider, right? Financial providers, FSP's business, in case of DHFL, actually, because, there are other, when we come to discuss Reliance Capital, it's a different type of financial service provider. It's not at all it is very, or each of these 3 FSPs that have gone into insolvency have very unique business models that you do not see in other insolvency resolution processes. And when we handle the other 2 cases also, you'll be able to see the kind of issues which are so unique to FSPs that you do not see in insolvency resolution processes that come out. Sorry, Nilang, you're saying something?
I was just going to say, no, I just wanted to sort of supplement that point, Avinash, that, exactly as you said, not only are they different, but also each of these 4 companies are very different in what they did. From RNFS to Reliance Capital, they're totally different business models, right? Because RNFS was obviously, taking a huge amount of debt from the public markets. infusing it into a series of downstream subsidiaries where they had very individual infrastructure and other projects running, for example, to Divan Housing, which was a deposit-taking entity, remember, and was running, a retail and a wholesale business. It was much more, I think, like a bank, if you think about it, than any of the other three entities. Shrey, again, very different because it effectively did not do as much retail. It was a lot more, on the wholesale side in terms of its infrastructure assets, in terms of asset leasing and asset financing. And then finally, Reliance Capital is the most removed from all of these, right? Because it's a CIC, where effectively it's an intra-group NBFC, where within the ADA group, it sat as like, a consolidating entity on top of various business verticals. So you can see how each of these four, although all four are NBFCs, they're all extremely different in how they ran businesses. And because of how different they are in how they ran businesses, the issues which came up in resolving them were totally different. Sorry, I was just sort of trying to elaborate a little bit on the point you made.
Yeah. So, my third point is actually taking forward on the uniqueness of the DHFL process. Like, DHFL as a company had so much exposure to retail, right? It was essentially a housing loan company. It had different business verticals, but it had a huge retail book. It had, by retail book, I mean, it was essentially giving loans to people, home buyers, right? So it had a name in the market. It was a brand that needed to be protected. Now, unlike a normal company where you, like, let's take for example a industrial company, right? Like a manufacturing company, a steel manufacturing company. A definition of keeping it on a going concern would be to essentially ensure that the steel production goes on and people in the market buy the steel, and therefore cash gets generated in the company. So when the cash is being generated in the company, it means that the company is actually being operated on a going concern basis, because the asset as such continues and the cash is being generated through the asset which is continuing with the company. And that's an example of going concern for, let's say, a steel manufacturing company. However, with respect to a financial and a DHFL, right, the asset is its loan book. How is cash going to be generated from this loan book when the loan gets repaid? Now, what happens when the cash gets generated by the loan getting repaid is that its assets are getting actually depleted. Because let's say today I have a loan book of, let's say, 100 rupees. I get repaid 30 rupees of it. I might have 30 rupees in cash, but now I have only 70 rupees of asset which is outstanding in my books right now, which means the asset size has actually reduced to 70. How do I keep it running as a going concern? The way I keep it running as a going concern was starting to give more loans, right? And this is very atypical to any other company which is in insolvency outside of the FSP space, because any company which is outside of insolvency, you don't typically see in companies in insolvency giving out loans, because they are to ensure that they retain the cash, they protect the assets of the company by retaining the cash. But here, the assets didn't need protection because they were essentially cash, right, in the form of loans. There's no maintenance requirements that are there for this particular asset, but it needed to grow. And for it to grow, you needed to actually give out cash, start using the cash that is being generated by the company to create assets, which can thereafter create more cash in the form of interest. So that is the uniqueness of the business model. It is, I think I put it in as simple a way as possible for a lawyer. There were multiple, issues involved with respect to how to generate this loan book, how to protect this loan book and create more assets. And one of the, significant value addition that was done by the administrator to DHFL was ensuring that the brand value of DHFL, its distribution group, it's the employees who were there in charge of developing the assets of developing the brand of DHFL, being able to build the loan book of DHFL. He was able to ensure that that particular core asset and core business continued. There was no run on the books of DHFL. He was able to ensure that this particular asset continued to generate more cash by virtue of just recovering the outstanding loans, but by virtue of actually giving more loans and generating more value by actually interest being paid on those loans. And therefore the asset was also able to, even though you don't see substantial increase in asset value during the insolvency process, but you was still able to ensure that there was no depletion or run on the books of the company during the insolvency process. And this is very unique to a financial service provider as compared to any other company which is in insolvency, which actually doesn't typically go out and give loans. And that the fact that the brand value, the asset value, the distribution network were maintained was one of the key reasons as to why there was a successful resolution in a quick manner. Because if the continued attention to maintaining the brand and the asset value of the company had not been given, then over an 18-month timeline, there could have the space that DHFL occupied in the market could have been easily occupied by some other person by taking over the distribution network. The fact that they managed to protect it during this period was commendable and was a testament to the value that was finally provided for acquiring the company under insolvency. Now, the fourth point that I wanted to mention was with respect to the resolution process itself. Of course, DHFL being a financial service provider had different business verticals. So they didn't, of course, their bread and butter was providing loans to home buyers, which was their retail assets. In addition to that, they also had a substantial wholesale book, which was basically giving loans to home developers. And they also had certain assets with respect to SRA projects, which were unique to Bombay itself. So they had three different types of assets in order to make and if you see in the market today, there might be a certain bidder who is interested in taking retail assets, which are typically considered to be less risky than a wholesale asset. Whereas there are some investors in the market who actually prefer wholesale assets because the returns are higher while the risk is higher. And similarly with SRA, where the returns are higher and the risks are higher. It'll be the market pool for investors in this company would be very less if you clubbed all three assets together and sold it to the bidders, because then you will need to find only bidders who are able to come, who have the capacity or the ability to acquire all three assets. And that is something like it is against the norms of increasing competition for an asset. And therefore, what happened with respect to this particular company was that the assets of the company were split into three different business verticals. The idea of resolution was that the bread and butter of this company is, of course, its retail business. But however, there can be other bidders who can come for the other businesses of this company, which is the wholesale business and the SRA business. And as and when a successful resolution is achieved for, let's say, the highest bidders are achieved for each of these three business verticals, they'll be tied together in order to form the successful resolution plan for the purposes of this entity. There was no precedent before this with respect to, at least that I am aware of before this, where this attempt was made with respect to achieving a successful resolution for an entity which had three distinct business entities. Now, of course, we didn't have the benefit of the Regulation 36B, which now permits this. Earlier, this particular, while this was not specifically prohibited, there was no enabling provision to actually provide for this. However, there was an attempt made, while the final resolution plan that got done was by Piramal, who took over the entire entity. There was an attempt made for the purposes of splitting the business into three different verticals. The idea was for the purposes of increasing competition. You could always, there are certain foreign investors who like to buy wholesale assets. We could have always, sold DHFL along with the retail assets to the successful bidder with the wholesale assets, because what are wholesale assets? Wholesale assets are loans. And today, already in the market, there are loans that are being traded. This would have been a similar loan trade which would have happened. So the ability to actually carve out an asset and sell it to a different bidder is much simpler in a FSP, because these assets are essentially loan assets which are already tradable in the market, which are being traded. There is a separate securitization framework as well as a September 24 framework, which is there for both standard assets and stressed assets. So therefore, this particular while the idea of transferring wholesale assets by itself was not new, it was novel in order to transfer the wholesale assets to a successful bidder as part of an insolvency process and as part of a resolution plan, wherein the successful bidder was going to take over only the retail assets. Now, this was of course unique. There was a proper process document, the expression of interest. There was quite considerable interest that came for this entity. There were, at least 4 bidders who actually submitted a resolution plan. In fact, the first bids that were received, there were only 2 bidders who bid for the entity as a whole. There were actually 2 other bidders who availed of this framework and bid for only part, like, the wholesale and the SRA assets. But however, of course, there was since the competitive tension got built up, there were mostly the lenders got the highest value in the option 1, which was basically the entity as a whole, and therefore the successful resolution happened with respect to the entity as a whole. But definitely splitting this business into 3 and identifying investors, pitching these businesses to the investors who will find these assets attractive, helped in the competitive tension building up for this asset, making it much more attractive and making it much more, it looked like people who would otherwise not have preferred for taking an asset which is having complex assets. It simplified it for those bidders so that they were able to only look at those assets that interested them. And it's also a learning for us, because as advisors to administrators, it allowed us to think outside of the box to see that while the resolution, while the IBC requires for the corporate debtor to be resolved on a going concern basis, it was important to look at what is the asset of the corporate debtor and look at what the intent and spirit of the code was when it wanted to resolve the entity as on a going concern basis. It was never the intent that the entity has to be resolved solely with one bidder. There was always various options available under Regulation 38 with respect to achieving a going concern resolution, including by virtue of selling certain assets to a third party. And this is exactly what was achieved during that. The fact that the framework was there for the taking, it just needed us to think a bit out of the box for us to be able to read the 3-4 provisions which are there under law together to be able to come up with a framework that achieved the purpose that we wanted to, which was essentially maximizing the value, at the same time complying with the provisions of the code. So this was another unique part which we saw in DHFL, which really challenged us. And we do believe that the fact that we were able to come up with a solution increased the competitive tension with respect to this particular asset. The next point that I want to go to is something I've already touched upon. My 4th point. The 5th point was, of course, on the competitive tension itself. Something that evolved outside of what happened in the DHL process. This is, that I will not be able to go into details of this because most of it is not in the public domain. There was considerable amount of competition between the 4 bidders who had participated in the process. Of course, Piramal was the successful bidder. However, there were multiple rounds of negotiations that the lenders undertook in order to arrive at the successful resolution applicant, which therefore it appeared as if this negotiation process was an unending process. There were certain unsolicited bids that were received, which the COC was debating whether to consider or not. Finally, the plan that was finally approved was pursuant to request made by the COC, and the COC received those plans and they were put to vote. Now, therefore, there were 2 sorts of difficulties that were involved, which got taken up at, this sort of issue, which was there across various other processes as well. So I wouldn't say this is something that's unique to DHFL. This was there across processes where there were unsolicited bids, there were multiple negotiations, protracted rounds of negotiations, COC undecided on whether they maximized value. This was something that was sought to be addressed in after pursuant to the ILC committee report. The IBBA regulations were amended. 39(1)A and 39(1)B were amended to provide that the resolution professional will seek only one modification in a resolution plan or improve the resolution plans through a challenge mechanism. And the second amendment that was brought in was that the COC will not consider unsolicited plans. So these are the two amendments. Of course, there is this particular amendment, what its intent is, whether it is seeking to only address unsolicited bids, does it actually cap the ability of a COC to negotiate? Was that the intent of the law, to cap the ability to negotiate? These are currently already being debated in another matter, Reliance Capital. So we'll not be able to comment on it because currently it is in litigation right now. And that question will get answered only when that litigation concludes. So you'll not be able to comment on it right now. But one of the it does appear that the experience in DHFL, maybe the process could have concluded a month in advance, but maybe we couldn't have identified or maximized the value if it had concluded a month in advance if there was no protracted negotiation. So these were learnings that were in DHFL, which seemed to be borne out in the amendments that happened in the CRP regulations. And now those amendments are now being tested before the NCLT and the NCLAT. And that's something that's for people to see because currently the matter is pending before court.
Yeah, I was going to say, and it's actually being tested in a matter we are already doing, which I will talk about tomorrow. Yeah, which is Reliance Capital. So I don't know if you already mentioned that. I missed that.
No, so that's the matter. So I hadn't mentioned that it wasn't Reliance Capital. So we'll take it up tomorrow. Yeah.
Correct. I mean, in fact, it's a critical piece of thinking under the law because I think when the BLRC was drafted, the economic theory advice at that time was keep it all market driven. Let people decide what mechanisms. Let people decide how many rounds. Let people decide whether they should have more rounds after announcing X number of rounds. Open slate, right? I think what the DHFL experience taught us was that very difficult for a COC after it has said it's going to do X number of rounds to ignore money lying on the table. If after the completion of those rounds, one of the bidders or another bidder comes in and says, "Here's X thousand crores more." I suppose every member of the COC has its own board and own committees and own regulators and inspectors to think about. So that's something they find very difficult to do. Having said that, I think the counter theory over there is that if you don't do that, you have what is called the stalking horse phenomenon, which is why should have, let's say Avinash and I are bidding for a company, right? I can pay 10,000 crores, let's assume. Why should I make a bid of 10,000 crores? There's no point. I should just watch for what Avinash is doing. He's starting at 3, going to 4, I'll say 4.5, 5, 5.5, 6, 6.5. Then I'll stop. Then Avinash goes to 7 and then he stops. I wait, I watch. Is he really going ahead with 7? He's going ahead with 7. Okay. Here's another 1,000 crores. 8. Right? Or even 1,500 crores, 8,500. Shake up the process. Avinash can't go to 8.5. Or doesn't want to go to 8.5. And the COC is confused. It's an extra 1,500 crores. So maybe it takes me. And certainly today, the thinking is that it will, the COC is more or less obliged, or certainly has the ability, if not obliged, to take my offer. But what that means is I have saved 1,500 crores, right? Because I've been a stalking horse to Avinash's bid. So that's the other counter theory in terms of, whatever they call it, economic behavior or behavioral economics, whatever it's called. That it's actually when the COC takes a bid which has not been solicited or changes the manner in which it does rounds, it encourages people to not give their best bid and prevents what is called irrational exuberance, I think again by behavioral economists, that when someone feels that this is absolutely the last round, the bidder may come in and say, I really, really, really need this company. So I'm going to throw in a number which I'm sure will beat Avinash, right? And therefore indulge in irrational exuberance. But if I know that this is not the last round, they're just saying it. बाद में एक और round होगा, बाद में उसके एक और round होगा. So why should I go crazy? I'll give a reasonable number. I'll play along later. So anyway, depending, there are many arguments on both sides. You may fall on either side, but that's certainly the big debate right now. Which approach is the better way to do it? And I think, as Avinash mentioned, post DHFL, the regulations were fixed somewhat to factor in for a limited number of rounds. But since then, there's been interpretation, by NCLTs, etc., which argue to the contrary, but also in favor. So, there are contrary judgments at the NCLT level on this point, on whether a limited number of rounds is to be forced on a COC or not. But sorry, I just wanted to touch very quickly before we round up. I think, Avinash, I don't know if you had much else. I want to talk about Batra books.
My last one was NHP. So, but yeah.
Okay, you want to pick that up, and I'll do Batra. You haven't touched on Batra books much.
No, not yet. You can do Batra books. I can do NHP later because that's a distribution point.
Okay. Then you can take a break and have a glass of water or something. Okay, so very quickly, I want to talk about this thing called Batra books. Some of you may have read about it in the newspapers. But it was a fascinating piece of fraud discovery, which I think Grant Thornton, which was the then avoidance diligence process advisor, what they found was that in DHFL, and this is all public news, and there's also been court filings made in relation to this, is that there was a large amount of transactions which were fraudulently reported, and effectively what was called the Batra books, because apparently this was a transaction carried out in a supposed Batra branch, and basically the suggestion in the books was that various retail loans were given to Amar, Akbar, Anthony, etc., and the actual loans were not given to Amar, Akbar, Anthony. The allegation is that the loans were instead, although shown on one piece of books and record keeping as loans given to Amar, Akbar, Anthony, actually the loans were given to XYZ corporates, and the way this was done was loans given to many retail investors of 100 rupees each, but 10,000 of them were then actually a front for loans given to, say, 10 corporate houses or real estate developers, etc., which were much larger in amount. And the loans to which entities did not get reviewed internally by the relevant investment and lending committees, and would not even have passed their standards. It's the general allegation. So there was a front showing loans given to all these people, when actually loans were given over here to someone entirely else. And what was given here was not shown on the real books. It was kept on the side books. This is the allegation about the Batra books. But this is a significant fraud which is alleged to have happened in DHFL. And of course, applications have been filed to unravel this. And it's still subject to the court process and review and decision. There's a lot more detail, of course, in relation to the Batra books. Things I am, curtailed from speaking in a general public forum about. But I have to say, when I first saw it, I just sat there thinking, wow, this is, an intricate web of reworking. And just looking through it and trying to unpick it and resolve it took us several days, let alone understand it. Sorry, I'll hand back to you, Avinash.
So, yeah, I think the next point I wanted to take up was NHB. So NHB is, of course, the National Housing Bank. They used to provide, they still, I don't think they provide anymore. They used to provide for financing, so, essentially low-cost financing to housing finance companies. This is their mandate under law itself. They used to enter into what commonly people used to call as memorandum of arrangements. These memorandum of arrangements essentially allowed NHB to provide financing to DHFL. The security that used to be created for this financing was certain identified loans. So essentially the money that NHB gives to DHFL will be utilized to be disbursed to identified borrowers, and the receivables from these borrowers were tagged to this loan and were created as security for solely for the discharge of the NHB debt. Now, this people could call it as exclusive security. However, what this memorandum of arrangement said and what is also contained under Section 16B of the NHB Act is that the receivables that are to be received from these specific accounts which are tagged to the NHB loan are considered not as assets of DHFL. They are supposed to be considered as assets of NHB, which is held in trust by DHFL. Now, this is a statutory provision which is contained under Section 16B of the NHB Act. This was also reiterated in the memorandum of arrangement, which is provided for between NHB and DHFL when this loan was taken. So the question that arose when DHFL went into insolvency was that, is this an exclusive security or is this asset held in trust, right? And I'll tell you what the consequence of these two is. If it was considered as exclusive security, then NHB would simply sit in the COC as a secured creditor for its entire exposure. It will be, it had given, let's say, a loan of 2,000 crores, right? If I had given a loan of 2,000 crores out of an entire admitted debt of 87,000 crores, it would be considered to be a secure creditor for the 2,000 crores. And the distribution as per whatever is agreed by the COC for all financial creditors, including descending creditors if NHB was to descend, would be paid to NHB, and NHB would not be able to claim any interest over these receivables that were tagged to its loan, right? That is what would have happened if it was a secure creditor having exclusive security over these assets. However, if we were to consider NHB's argument being that this is actually the receivables from the borrowers to whom this NHB loan was disbursed. If that argument was to be taken, then the consequence of that argument is that the entire receivables will have to be directly paid to NHB, irrespective of whatever security is. And these were, for the purposes of completeness of fact, these were very good receivables. The entire 2,000, let's say there was a 2,000 crore debt outstanding for NHB, then this entire 2,000 crores was capable of being paid with these receivables. So that was the consequence. So essentially, if it's an exclusive security, it would have been subject to whatever COC decision or distribution was taken for secure financial creditors. If it was not an exclusive security, but actually a asset held in trust, then the consequence would have been NHB being paid out fully. So the question that arose before the lead lenders in DHFL, of course, contended that this was actually security because they were sitting in the COC, they had filed a form, they were sitting in the COC, and therefore they can't contend that these assets are held in trust, because if they're going to be held in trust, they should sit outside of the COC and just take the receivables, like the way securitization loans are being undertaken, where loans have been transferred to certain external where loans disbursed by DHFL have been transferred to other creditors, and DHFL is acting only as a collection agent and holding the receivables in trust for those lenders. That was the lead lender's argument. NHB's argument was that they have a statutory right under Section 16B. This receivable is never considered to be the asset of DHFL, and therefore cannot be distributed by DHFL as part of its asset pool. These assets have to be transferred directly to NHB on account of the statutory trust that has been created. This point was contended before NCLT. I think this is what happened at NCLT is very important. I think both the COC and NHB recognize the fact that at the end of the day, this is a distribution issue. This is not supposed to stop the resolution from concluding, right? Because it's basically a fight of whether NHB is supposed to get 2,000 crores or is it a fight for NHB to get less than 2,000 crores. That's going, at the end of the day, this 2,000 crores is going to come out of this 36,000 crores, which is being paid in the pyramidal plan. It is not that if NHB wins, the pyramid plan is going to become 40,000 crores, right? So the bucket is of money is still fixed. So therefore, it was a distribution issue. Both the parties were commercial, and they entered into a memorandum of understanding, which was actually submitted before NCLT when the matter was pending, wherein they agreed that the entire outstanding debt of NHB will be placed in escrow from the proceeds of the resolution plan. And this will not be utilized for any other purposes other than the distribution that is finally determined in accordance with NCLT, NCLAT, or Supreme Court decision. On account of this particular understanding, the resolution of DHFL in NCLT could progress. It was a quick progression. The NCLT approved the resolution plan. On the same day it approved the resolution plan, it also issued its order in the NHB matter, wherein it held that there is, with respect to the question of Section 16B, the COC's argument was that IBC overrode 16B because there was inconsistency between the provisions of IBC and Section 16B. NCLT did not accept that argument. NCLT said that there is no inconsistency between what NHB say, what the NHB Act says and IBC says. NHB Act simply says that these assets are to be held in trust, and therefore these assets will continue to be held in trust, and therefore held that NHB should be paid the entire receivables that are going to be realized from this trust. The lenders went on appeal to NCLAT. NCLAT also upheld this, and now the matter is pending in Supreme Court. So the question, and I think this will be important for discussion when we present the Shrey case as well, because there were similar lenders over there. The matter is pending, is sub judice over there. The fact situation, my partner Suyash will be able to give more details over there. But essentially the question was, when is there any inconsistency between the provisions of the NHB Act and IBC? At least NCLT and NCLAT have held that there is no inconsistency. The matter is still pending before Supreme Court for its determination. I think the final point that I wanted to mention is something related to the avoidance transactions. I think Nilang had mentioned to you about the Batra books avoidance case. There was considerable amount of the receivables from this avoidance, at least the claims that were made in these avoidance transactions were considerable. Whether they are realizable, whether they are not realizable, for commercial parties to decide. However, as part of the resolution plan, the COC, in exercise of its commercial wisdom, determined that the receivables out of these avoidance transactions is being transferred to the successful resolution applicant for a consideration of 1 rupee. Now, this was a subject matter of litigation because at NCLT, one of the debenture holders, 63 Moons, contended that this is an unfair decision undertaken by NCLT. NCLT, however, did not accept that argument and said that the resolution plan is compliant, including this 1 rupee payout. The matter went on appeal to NCLAT. NCLAT was of the view that 63 Moons is right in its argument and concluded that to the extent the resolution plan states, that the avoidance transaction receivables are to be paid to be retained by the resolution applicant and not by the financial creditors, it modified that resolution plan to state that it will be paid to the creditors because creditors are the only persons who are entitled to be beneficiaries of this particular avoidance transaction monies. The matter is currently pending in Supreme Court. Supreme Court has passed a stay on this order. It will be finally determined by Supreme Court as to the essential question as to what is to be, who gets the benefit of avoidance transactions. And that's, while it's not related to financial service providers, this is something that was very keenly contested in NCLT and NCLAT and is actually pending before Supreme Court for final determination. Of course, it's a commercial decision at the end of the day. The COC gets to decide, and pursuant to this, and of course, pursuant to the Venus Recruiters case, there were IBBI amendments that were brought about, which now specifically provide as to what needs to be contained in the resolution plan with respect to treatment of avoidance transactions, which give now a bit more clarity with respect to how avoidance transactions need to be handled. And of course, the Venus Recruiters division bench judgment has also come out with respect to the manner in which avoidance transactions can be pursued after the resolution plan has been approved. But the question as to who gets to be the beneficiary of this, it will be a point that will be now to be settled by Supreme Court in the 63 months appeal, which has been filed before. In the appeal filed by Piramal and the lenders against the 63 months case before the Supreme Court. These are the points that I wanted to talk about with respect to DHFL. So, if we can now open the forum for discussions and Q&As. We are like my discussion points have I just rounded it up now.
Participants can ask the questions. I guess they don't have any questions to ask first.
Like we were very comprehensive. If participants want to email questions later, that's fine as well.
There is a hand up. IP Jain and Gupta. Mr. Jainaran Gupta seems to have a question, but probably he can't hear us. So,
yeah, I am hearing.
Yes, sir.
Actually, I was just pondering how practical it is feasible to contest the PUFE application before NCLT after the resolution plan has been approved, because there will be a total lack of interest on the part of the CD, who may be in the hands of the promoters if it was MSME, and even COC may not be so much interested in putting bad money after good money after the bad money to contest the application. So how far it will be practicable to contest this PUFE application?
Shall we, Mr. Batra, would you like to answer that? Shall we jump in?
Well, I think you should do it based on your own assessment in these cases. I'll make a general comment after that.
Sure. No, so I was just going to say exactly that I think, this is relevant not only for FSPs, but also for, companies more generally. And I think that's absolutely right, especially when the promoters bought back the company. But even if not, I think it really depends on the kind of claims to show where there'll be interest. I think there will be instances where, the claims will be pursued by a corporate debtor, which is not the erstwhile promoter, because there will be value extraction which is possible from those claims. Sometimes it will be possible again for the COC, where, as you say, the light is at the end of the tunnel is closer to see. But and the examples I spoke of are a very small fraction of the overall scenario, and therefore, in a majority of cases, most people will not pursue it, for want of money, for want of time, for want of the prospects being low, etc., etc. And I think there needs to be an answer to this, and I think there has been discussions in some forums about whether litigation financing will fix it, selling these claims will fix it. And I think, eventually we'll have to get to that stage where there'll have to be much more comfort amongst the COC and among stakeholders to be able to, and there will need to be obviously litigation financiers as well who are willing to come and buy these claims. And therefore the COC can monetize these claims by selling it off, even if it's, for a few pennies, but selling it off so that the people who are more proficient at this, understand the risks, understand the process, can take on this litigation and then continue it to extract value. And what could happen over time is, if this model works, where this COC is able to sell it for a few pennies, but more importantly, the buyer is able to enforce and recover, it will become a workable model in the market. And there'll be more players coming into a market to try and buy these claims. And therefore, the COCs will increasingly get better recoveries when they try and sell these claims to third parties. That was it from me, Mr. Batra. I don't know if Avinash, Suhash, Amrita, you had anything to add before Mr.
So
Batra.
my two pennies on this, in addition to what Nilang you mentioned, and I'd like to sort of also echo that we do need to develop a secondary market for the avoidance transactions, which also mean that we need to create litigation funding as a market. But it's easier said than done, because in other parts of the world, why litigation funding has worked is largely because the legal advisors are able to give a very definite opinion as to what will it take to close these proceedings, what are the chances of success, and those opinions are based on the fact that the legal systems in those countries do provide a degree of visibility and certainty on how much time it will take, how much cost it will entail, and what are the chances of success. In India, all those are big challenges. It's very difficult for any legal firm or a lawyer to be able to give an opinion which is something which is adequate enough for a litigation funder to be able to take a risk. And it is all the more challenging because of the reason that we have two tiers of appeals coming out of any decision that the NCLT may take. And those would take their own time, which means that it could at times be open-ended. These do create difficulties in creating a secondary market, as enforcement of contract is something we don't really have as a boast, something to boast about. Now, having said that, one can't just give up and not consider other ways of improving. We are aware from the discussions in various forums that the Ministry of Corporate Affairs and IBPI in particular are very, very concerned about the fact that we haven't really seen much traction and results in these applications, and that the amount that is locked in these proceedings is so phenomenal that just imagine if these amounts were to come back into the economy, how much contribution that they will make. So from a larger perspective, macro level perspective also, this is something which needs a solution. Now, the last comment that I wanted to make was that while of course one has to continue to hope and keep trying that things will improve with more number of NCLT members coming in and our efforts on developing the secondary market happening, and the courts taking these on priority and rendering further closure. We still probably need some more innovative solutions to this. And my sense is that we might actually see in the near future some very important steps in this direction. The thinking is at a very, very, very preliminary stages. Nothing is really shaped up as even as a concrete thought process as to how one can expedite and provide more productive outcome of these, expeditious outcome of these. But yes, it is, in my opinion, at the front burner of the policymakers. It is taking a lot of mind space of the policymaker. They have been discussing it at various platforms, in particular in Manila in Philippines, in a conference that was held where Asian Development Bank hosted a conference. there was a couple of sessions on avoidance transactions as a global issue, not just an Indian issue. And quite a big team from India was there to attend. All this shows the importance that is being attached to this subject at the policy level in terms of finding a solution. And I'm quite hopeful that in a very short period of time, we will, or we should be able to see something concrete coming out as an alternative ways of doing this. Although the simplest thing to do would be to probably set up for 2 years a special bench to only do avoidance transactions. 2 designated benches in Delhi, 2 in Bombay, or maybe 1 at least, and 1 day in other benches being spent on avoidance transactions to deal with the workload as the benches are doing about the resolution plans that are pending today. These are being taken on priority. Admission applications are being taken on priority as the cost list shows. So if something like this is done on a dedicated basis for 2 years, I'm quite sure we should be able to streamline. This is, of course, besides or in addition to the other measures that are required. So over to you, Nilank or Avinash. How you want to proceed?
I think we were done for now.
Yeah.
No, I just meant any supplementary comment that Avinash or Suhash or others.
Oh, sorry.
Yes.
Sorry.
No,
yeah,
nothing else actually. Just that I think right now, with respect to PUFE transactions, the transactions which are at least progressing in NCLTs and in the few transactions that are progressing, which are being pursued, seem to be more in relation to where an asset has been transferred, because an asset is something that you can actually see being there, and therefore the ability to bring it back into the corporate debtor by avoiding the transaction seems to be something that lenders are keen to at least pursue, so that they know that at the end of it this asset is not going to go anywhere, and therefore it can be brought back. Cases where money has been transferred and therefore it's a recovery action, as Mr. Batra, you mentioned, enforcement of contracts is is where we are found very wanting in that. Recovery of money with respect to money that has been paid out, and even let's say we even get an order which says that a certain money has to be paid, the ability to enforce that order is found wanting. So I think right now the nascent stage at which PUFE transactions are, the only few interest that people actually see in getting avoidance done is where an asset has been transferred. Because even if it's a preferential transaction or let's say an extortionate credit transaction, we haven't seen, but it's an undervalued transaction where the asset has been transferred for value which has not been fully paid. We do see that the people, at least the creditors, because they are the ones who have been affected or prejudiced on account of those transactions, they do see value in pursuing those, getting those avoided, and bringing it back within the liquidation estate for the purposes of its sale, either as part of the CIP process or as part of the liquidation process. So, we do see that interest being shown. There is keen interest in following that up, but of course, there is a lot to be done with respect to making this a successful model in India for being able to pursue transactions, especially on account of the kind of money which is kind of value for these transactions that are being identified right now.
True. And also, Avinash, although of course we haven't really seen much positive results, but the fact is, I think we have about 65 odd crore of recovery, although it's very significant, but that probably was more like cash. But what we have in kind was about 6,000 crores in JP.
Yeah,
where
exactly.
land worth 6,000 crores was brought in. So if you add that up, although it's in just about 3-4 cases, it is not a bad number. You're looking at roughly about 6,000 crores. But yes, we could have done better.
I should also mention that, I think, sir, what happens is a lot of banks and COCs, especially in the larger cases, are worried that even if, I think as Avinash is pointing out, even if orders come through, against promoters or promoter entities or wherever the money's been siphoned off, their worry is that the money will actually not be sitting in India and will have gone overseas. And what is the point of, getting an order where the assets in India are negligible and the assets sitting overseas, to kisko pata kaise lenge? So I think even on that front, and so if you remember the Insol conference a couple of weeks ago, there was a panel which talked about how asset tracing overseas could become more relevant in an Indian context, where even if assets are sitting overseas, a combination of Indian law and English law is being used by some market players. And this was in the Economic Times a couple of weeks ago as well. It's being used by some market participants to trace the asset overseas. So the fraud may have happened in India. The money may have been gone into the UK and then St. Kitts or whatever it is. But the combination of that Indian law and UK law orders can be used to follow the money to an eventual jurisdiction. And even though Indian law orders don't carry necessarily as well, an English law order carries very well in the Commonwealth, and therefore follow the money to target the asset, attach or arrest the asset, and bring the money back into the system. So I think as banks see that happening, that even if money is run away overseas, you can bring it back. There will be maybe a little more value and emphasis and impetus in relation to some of these avoidance transactions.
Yeah, Nilang, and again, this is probably the best way forward, undoubtedly. The only difficulty is the cost involved, and the Indian lenders, big public sector banks will be very, very careful and cautious about being a bit more adventurous and liberal in spending the kind of money, unless, of course, they have a degree of certainty that the money will end up on the doorsteps of India at some point in time. And then on a cost versus benefit analysis, they're persuaded that benefits will outweigh the costs at some point in time. So this is again linked to the point of litigation funding. If we have litigation funding coming in, then people would be willing to let go, even if, as you mentioned, the assignments take place at a lower cost, no doubt, but at least the movement starts. I think, Radhika, we are good.
Yes, sir. So there is one question in the chat box written by Mr. Rajesh. It's written that shall the RP take control over the assets, maybe the FDs acquired by the FSPs while giving guarantees?
Sorry, I'm not sure I followed the question. I'm trying to find it.
It has been sent to directly in the chat box. That's why you are not able to read it. I'll repeat the question. Shall the RP take control over the assets, maybe the FDs acquired by the FSP while giving guarantees?
So who's given the guarantee? The FSP? I'm not sure. So has the FSP given guarantee and therefore taken FD as a security? Is that the question?
Yes, sir. Can the RP take control over the assets? This is the main.
Yes, sir. Yes, sir. Particularly, that is the
Bank
question.
guarantee. I'm assuming it's basically a bank guarantee,
Yes.
which has been.
Perfect.
It won't be, because it's a margin money that has been given to you. The asset, let's say, think about it from the perspective of the person giving the fixed deposit, right? If the person gives the fixed deposit and marks it, it's only lien marked in favor of the FSP. The asset is still belonging to the borrower. So, the administrator of the FSP will not be able to take control of that particular asset, because that is actually only a security which has been created in his favor and is not his own asset.
Okay, sir.
Sir, good afternoon. This is Ramachandran Subramanian from Chennai. I'm handling a liquidation assignment, which is a very interesting one. I have a couple of questions. Is the right time to, sir?
Yes, sir. Please go ahead.
Yeah. In one matter, it is about the bank guarantee, as it was a subject matter which was just discussed. In one of the clients, this is a project which the corporate debtor had earlier entered into the contract in the year 2009 for construction of a power project at Chhattisgarh for 995 crores. All right, sir. And at that time, as part of the stipulation, the corporate debtor had brought a underwriter for 168.5 crore as bank guarantee, which was valid only until December 2013. And by September 2013, they have given the COD, commercially operable thing, and business that project was commercially viable for operation. Maybe there was some last mile finishing work touches to be given. But however, in 2015, this corporate debtor and the erstwhile client, they both enter into a fresh agreement. Now, what I say is, the moment this fresh agreement has been entered into by keeping the same bank guarantee, I say that the bankers are already walking out of the arrangement because bankers are silent on this new agreement. Is it right, sir? Right way to argue.
This is a very case specific question, right? So, this will be entirely based on what is contained in the guarantee. So,
true. And also,
bank guarantees for a specific, I'm sorry, bank guarantees are given for a specific cost. That was for implementation of the power project. Power project has been completed. In 2013, COD has been issued by the client. And that means the project is commercially successful, viable. 2014, one more year, they might have got it extended. Nobody is coming in the way. But and there is a further agreement to which if the banker is not giving his consent, that means this is an void. This particular agreement is void. And again, there has been one more agreement earlier when the CARP was in motion. And at that time in the year 2019, they have got into another agreement. So when two agreements in succession and the banker has nowhere conveyed his consent, we only say we now take the stand. And eventually the bank guarantees were encashed ruthlessly for a sum of 168.5 crore in the year December 2021, 12 years after it was issued. So for a bank guarantee for a specific cost of 995 crore power project, when there is a COD certificate available as of September 2013, and for the same client to encash the bank guarantee in the year 2021 December, and they are refusing to come and take part in the arbitration, though they appointed their nominee arbitrator, by subsequently altering the stand, saying that their state arbitration tribunal will have a jurisdiction over even the findings of the central arbitration tribunal, which was then on having the mandate on was taking the proceedings. So eventually the tribunal got confused and they terminated the mandate themselves, and they simply, now the matter is hanging fire. Now we do not know where to approach and where things will have to be taken up. However, we have lately moved an application before NCLT for a direction to the client, erstwhile client, to refund the bank guarantees, whatever money, pending conclusion of this arbitration, whenever and as and when it is going to take place. Because state arbitration tribunal, we understand, it takes not less than 25 years for it to come up with its findings.
Well, sir, I mean, I think as Avinash mentioned that this is a case specific, so it becomes difficult for all of us to be able to respond to that. So
fine, sir. I got it. I got your constraints of limitation. And another issue is we are trying to bunch so many of the NRRA assets, sir. There is a receivables. And as this is a first of its kind, is there any way you can share with me some details, what all precautions that we have to take for in this particular thing?
Sorry, what do you mean by NRI assets?
NRRA, not readily realizable assets. These are all by way of claims, ongoing arbitrations, and such claims we are in the process of selling it to a prospective investor who will be bringing in. Say, for example, we say that 500 crores is realizable. He may put the number at 300. All right, at 300 crores, all right, what is the amount that you are going to pay? Maximum available time is 3 years for you. He may pay in about a 10 crore or so as a token amount, as an upfront. And he may meet the liquidation process costs upfront, all these two. The remaining amount, we are trying to stipulate a bank guarantee payable, and then if it is not paid by 3 years, the bank guarantee will be encashed by our financial creditors. And also the remaining, whatever he has done left incomplete, will be automatically taken over by the financial creditors, and it will be straight away either taken to liquidation or it will be taken back by the financial creditors as onerous asset for them to eventually follow up these things. Will this be all right, or we have to insert any special conditions so that it is a fair
So
all through?
This is in liquidation, not CRP, right?
No. CRP is long back over, and it is now in the 4th year of liquidation now, for which you already obtained the necessary permission, approval.
4th year, wow, okay. I didn't have any immediate supplement to that, sir.
neither do I.
Well, no problem. Because these are.
Thank you. Good luck.
This one, we would like to complete it also.
Thanks. Thank you very much, everyone.
Radhika, over to you.
Yes. Any other questions, participants?
So, sorry, Mr. Pandya had raised a question in the chat box that I thought might be worthwhile sharing with the rest of the group as well. I think on ILNFS, I think one of the things he'd mentioned was that what sets ILNFS apart is also the fact that it was not regulated by a single regulator. It was regulated because of its presence in diverse sectors. It was regulated by a whole bunch of regulators. That, frankly, that makes absolute sense to me. But I think one thing to keep in mind is most financial sector regulators, and I'll let Nilang and Avinash sort of weigh in as well, but most of the instances they would have seen of DHFL and Shrey and RCAP would have also involved other financial sector regulators weighing in. Unlike ILNFS, they may not have that much of an interface with maybe, say, the NHAI or the likes. But I'm sure they've had their war stories with with other regulators, including insurance departments, SEBI, and so on and so forth.
Correct. No, absolutely. And I think maybe we can touch upon this tomorrow when we go into Shrey and RCAP.
Makes sense.
Okay. Thank you. Thank you, Mr. Batra. Thank you, Radhika.
My pleasure. Thank you so much.
Thank you, Sumant Batra, sir. Thank you, Nilang Desai, sir, and the team members, Ms. Amrita and Avinash also. Thank you, all the participants. Tomorrow we'll have the session at 2, and the link for joining, as I have shared today, will remain the same for tomorrow. Thank you so much.
Thank you.
Radhika. Thank you, Nilang. Thank you, everyone.